offender code change. It is December 7, 2016. The purpose of on our future City Council agenda and the Rules and Reference Committee. In order to improve the efficiency and effectiveness with which repeat code violations are resolved, this ordinance amends the current code to clarify that no provisions of the Columbus City Code shall be construed to prohibit or limit existing remedies available by law, including but not limited to filing a civil complaint for injunctive relief or a criminal misdemeanor complaint in the Environmental Division of the Franklin County Municipal Court. And with that brief overview, I would now like to hand this over to Director Steve Shoney with the Department of Development. Thank you, Director.
Thank you, Councilmember Page. Thank you for working with us on this ordinance. This piece of legislation grew out of a community, actually two community meetings that we had early in the year. One was one of the mayor's essentially family reunion style meetings that we had on the east side, where we got a lot of interest in our policies on housing and code enforcement. The mayor asked me to lead a community meeting focused solely on housing, and when we went out and did the meeting, and I think Mr. Dunbar was there with us, and Dana was there as well with a large number of members of his team. The community rightly pointed out that we needed to do a better job of dealing with repeat code enforcement offenders, and that we were falling a little bit too much into the trap of, if you will, fool me once, shame on you, fool me twice, shame on me, and getting into a system where, or getting into situations where we would have homeowners and or tenants who we would come out, we would cite them, they would come into compliance for a short period of time and then fall out of compliance, and we'd have to start the whole process over. So what Dana Rose, our code enforcement administrator, and Mr. Dunbar from the city attorney's office and their respective teams did is they worked together on a new policy and some code clarification that makes it clear that the city does have the ability to, should we find that someone is a repeat offender, and I'll talk in a minute about what the limitations of that are, we have the ability to not go back to square one, even if they've come into compliance. But if they are habitually getting into this pattern, we can move more quickly to taking them to the environmental court. So specifically, what we're looking to do is if we have the same, if we have violations in the same section of the code within 60 days, we don't have to go back to issuing another citation before we take someone to court. If we have 3 cases of a violation of the same code within a year, whether it's been within 60 days or not, we have the ability to again skip that step. We believe that this will help make a substantial improvement to how we go about doing code enforcement, about how we deal with problem properties, and we'll set the tone so that hopefully our goal is never to take someone to court. Our goal is always to achieve compliance. So this is not about generating fines. This is not about generating court cases. This is about achieving compliance. Our true desire is that we will now set an expectation with our residents and with our property owners that we will come out, we will work with them on the first violation, but once something comes into compliance, we expect it to stay in compliance. And if it doesn't stay in compliance, we will move forward aggressively with enforcement action. So with that, I'll turn it over to Mr. Dunbar for any further explanation, and then Dana, Steve, and I are all available for questions.
Thank you, Councilwoman Page. To be frank, my role in this legislation is primarily very boring and very legal. What Director Shoney explained is true. We went to a couple community meetings, and the criticism we got was collectively, we, the city, that the folks who violate repeatedly aren't addressed sufficiently. I want to clarify, when we're talking about repeat offenders, it is not our high-end, worst of the worst people in the city repeat offenders. We drafted legislation, passed legislation a couple years ago to allow Director Shoney to levy significant fines on those folks he finds to believe to be the most egregious offenders in the city. What this legislation seeks to get at, and this legislation in conjunction with the policy Director Shoney just spoke on, are those folks that have never made it to environmental court, have never even become on the city attorney's radar. These are folks who repeatedly get a notice from code enforcement saying you're in violation of a city code. They fix it, but then they have a problem. So then another violation. As you're aware, Councilwoman, the way the process generally works, code enforcement writes an administrative citation when there's a violation. They try and work with that person. If it doesn't work, they bring it to the city attorney's office to refer it to environmental court. That period of time can take a while. These types of violations were never making it to the city attorney's office. We were not looking at them because that violation would be complied and closed out, and then we'd have a new one that would be complied and closed out. A garden variety example is someone who parks their camper on the front lawn. You can't park something on an unimproved surface, so code writes them, you got to move the camper. They move the camper, so code closes out the order. A week later, 2 weeks later, the camper shows up again. They write a new order. The camper goes away. So from the city's collective perspective at that point, those were initial citations that were complied. From the community's perspective, the stinking camper never left, not for any significant period of time. So what the ordinance does is strictly clarification. And just to be clear on this point, we are not seeking any authority that we do not already have under the law. The state code grants cities the rights to bring lawsuits to force property owners into compliance, regardless of what the city code says. We have that authority and we exercise that. And what we looked at, though, when Director Shoney comes to us to craft the policy, we almost worked it backwards. We said, okay, well, here are the types of instances that are problems. Here are the types of offenses and the repeat violations that we want to address. Then, as is often the case, hey, lawyers, do we have to do anything to the code to do it? And looking over the code, I realized I did not know this beforehand. I do not know many things. But when you look at the code enforcement enforces a number of titles within the Columbus City Code, 4 or 5 of them. When I look through those, some say upon notice of violation, code enforcement shall issue a notice, or some say may issue a notice. Some include a clause that says nothing in this code shall be interpreted to prevent any other remedies available at law, such as an injunction, such as a criminal case. Not every one of those chapters has it, and there doesn't appear to be any significant coherent thought to which does and which does not. So as Director Shoney said, and what we are doing is strictly trying to clarify in the code, the City of Columbus always has the right to go straight to environmental court when need be. And we do that. Right now, as we look at the code, there in a couple of these provisions says, code shall issue a notice. That triggers an administrative appeal process. So it turns into kind of a silly overuse of resources. If we've determined we got to go straight to court, but the code also says you got to give a notice that they can appeal to BZA, we have 2 things going on at the same time. We are strictly trying to clarify the code is the code. 99% of the time it's going to follow just like it says. But we have and always have had the ability to go straight to court when need be, and we will do that pursuant to the policy that Director Shoney just read to you. And that is all I've got.
Thank you so much, Attorney Dunbar, and I would like to welcome my colleague, Councilmember Michael Cinziano, to our hearing. Thank you so much for joining us. I will now give the floor to Dana Rhodes, the Code Enforcement Administrator.
I'd just like to say that I think Director Shoney and Attorney Dunbar have summed it up pretty good. I think this code change and this policy will help the neighborhoods. Specifically, we have a lot of neighborhoods where we get a lot of complaints about things in the yard, appliances, tires, outside, which affects the neighborhood, affects the value of all the houses in the neighborhood. I think this will help, educate people, and I think it'll make it better for the neighborhoods. Yeah, Attorney Dunbar did give a good example with the camper in the front yard. Another, probably one of the primary examples would be an inoperable vehicle, either, in the front yard or the backyard, and they'll get rid of the vehicle and then bring another one in. So if we can eliminate that, it'd be a great thing. Thank you,
Great.
Councilmember Page.
Thank you so much, Mr. Rose. Do you have any questions or comments? I do have a few questions, and just for whoever kind of wants to answer them. I was asked, why is this, one of the better ways to address the issues legally is, and you explained that, Attorney Dunbar, why, this was an option that we looked at, but someone said, why this and not something else, such as maybe giving a ticket? If you can answer that.
I will tell you, one of the biggest reasons that this is a great option is here in Columbus, we are blessed to have an environmental court. We are blessed to have this forum with a judge, with a court that is set both logistically to handle these types of cases in an expedient fashion, and also from a perspective handles these cases primarily, as opposed to them being mixed in with criminal cases and civil lawsuits and that sort of thing. So when you look at, well, why don't you do some sort of civil penalty, a ticket? One, no matter what we do, there's always going to be a right of appeal. So they're literally just like a speeding ticket. Most folks pay them without thinking much of it, but on every single one of those speeding tickets, there's an option to say not guilty and come down to the courthouse. So what we're doing is really bypassing that. Instead of having to issue a ticket that someone may pay or someone may appeal down to court, we're saying we want to make clear that we have the right to skip the ticket, whether it be a ticket or a citation or a notice. The reality is we can go straight to this venue that is very appropriate for these types of cases. And from our perspective, we don't see any reason to add another layer of process. Something to be clear about, though, is that when we say go straight to environmental court, there's process there. It's not like we're taking people straight to the finish line. I mean, that is a court. Both sides get heard. The judge determines whether or not a violation exists. The judge determines what is an appropriate remedy for that violation. So we're not taking due process from anyone. We are just, again, clarifying this right, which we have, to go straight to environmental court when we deem that to be the most appropriate remedy.
Thank you so much. And another question, and I don't know if you can put this in numbers or just kind of quantify, how many of the individuals who are receiving code violations do you think this could possibly affect?
Thank you, Councilmember Page. We haven't kept track of the repeat violators, although we do have those, but that's something with this passage of this ordinance, if it does pass, we're going to keep track of that and just see how much of a problem it is. I know it is a problem, and we've heard that from the neighborhoods, but we will keep track from this point forward as to how many we get.
Great. Thank you so much, Mr. Rose. Any more questions from me? Well, we do have a few speakers who would like to come down and offer public comment, and I will call each of you by name. If you could come down to the podium, let us know any organizations that you represent, and you will have 3 minutes to speak before council. So our first speaker is Mr. Lamar Peoples. Thank you for coming down, Mr. Peoples, and we look forward to your comments.
All right. Perfect. Good afternoon, Councilwoman Page, Councilmember Stenziano, Director Shoney, Assistant City Attorney Dunbar, Administrator Rose, and area commissioners. Thank you for hosting this public forum on Ordinance 3019-2016. My name is Lamar Peoples. As a community outreach coordinator with Habitat for Humanity Mid-Ohio, my role includes a plethora of duties, including advocating for the communities we serve. And that's why I'm here today. With an understanding that campers are a problem, I have a question. Could the reason why there's a repeat problem with blight in the communities be because some of these people don't have the resources to obtain home repairs on their home? Currently, Habitat is working in the Linden and Southside neighborhoods of Columbus, building new homes for homeowners and providing home repairs for current homeowners. Councilwoman Page, to quote a Dispatch article, quote, "A proposed change to the city code would clarify that property owners who don't comply with orders from code enforcement officers could face civil or criminal penalties," end quote. However, is there a way to help low-income property owners have access to home repair programs, like partnering with Habitat for Humanity Mid-Ohio to create a pipeline when individuals are having problems with their properties and refer them to organizations like Habitat for Humanity Mid-Ohio and others like Life Care Alliance, Rebuilding Together Central Columbus, Ohio, etc. The quality of work that these organizations do can reduce recidivism and save money and resources. So I agree with holding people accountable, and I think Ordinance 3019-2016 does that, and it lifts up communities. I also believe that meeting people where they are to maintain a decent quality of life that promotes safety and a sense of community comes by connecting them with the myriad of resources that are available right here in Central Ohio. Again, thank you, Councilwoman Page, for hosting this public forum on Ordinance 3019-2016. I can provide your office with some information about Habitat for Humanity Mid-Ohio programs, and I look forward to working with you to create partnerships and to create a pipeline from blight to repair and sustainability. Thank you.
Thank you so much. Oh, you can wait right there. Thank you so much for coming down, Mr. Peoples, and I do want to give Director Shoney the opportunity to address some of the things that you said, and to really thank you for your comments about the work that Habitat for Humanity is doing. And I would encourage you to not only give that information to my office, but also to code enforcement so that they can work as they're out, in the communities to make this information readily available. Director Shoney.
Thank you, Mr. Peoples, for coming down, and thank you for the work that you and the team at Habitat do. You are fantastic partners of ours in many, many things in keeping our community strong. A couple things I would point out. First of all, there's a reason why we are careful to leave ourselves some discretion in how we deal with these issues. Our code enforcement officers and the supervisors and Dana's assistant administrator and Dana are constantly asking the question of why. Why is this person in violation? Is this a situation where this individual doesn't have the ability to take care of this problem? And then they work very closely with our housing division to, if there is a financial reason why someone can't comply, to see if there are services that we can bring, to bring hands-on, to bring some of our own home repair programs, to bring other groups to bear. So we pay a lot of attention to that. Dana's team and Rita Priest's team meet on a regular basis to go over these issues and deal with individual cases. So we're very careful about that to make sure that, and this really is targeted toward those issues that are issues of will rather than ability. So when you have something like the camper that appears in the yard constantly, that's not an issue of ability. If you got the ability to get the camper there in the first place, you got the ability to figure out something to do with it. And finding ways to have folks accountable for those things. So thanks for your comments. I hope that answers some of your questions.
Thank you again, Mr. Peoples and Director Shoney. Our next speaker is Mr. William Logan. Again, Mr. Logan, you have 3 minutes, and please let us know any organizations that you are representing. Thank you for coming down this afternoon.
Thank you, Councilperson Page and Stinziano, and our directors here. I'm speaking on behalf of the Northland Community Council's Development Committee, and in addition to the Code Office. We're in complete support of the revision to the code. The Northland area represents 1/10 of the city's landmass and about 128,000 of its population. Our office generates approximately 20 code request investigations a month up in our area. A reasonable number of them are associated with the residential portions of our population. Simply put, repeat problems, as was already marked, vehicles particularly, commercial vehicles in driveways, broken down vehicles in the front portion of the yards. Tall grass hasn't been necessarily spoken of, but tall grass qualified as for occupied residents. People who just don't cut their grass, yes, they do leave it go 12 inches beyond in a couple of instances. We have an instance right now where a commercial vehicle, PMI officer was out, wrote citation for a commercial electric line truck parked in the front driveway consistently. The line truck was moved out from the front of the residence for 1 week after the citation was cleared, and it was right back. It's right back right now. Same problem. We spoke to the resident, and quite frankly, they said they felt they had the right to keep their work vehicle in their front driveway. That's their opinion. One question I do have for the department heads here: will the legislation, in effect, also commercial properties? I say examples, which I know Dana's familiar with me, writing up numerous graphics violations in the Northland area. There's a whole series of straight out prohibited graphics that routinely show up week after week after week, to the point where some of them we just cease writing them up because of the hassle involved and the time delay involved for everybody concerned. Thank you.
Thank you for your comments, Mr. Logan, and I will allow Mr. Rose to answer that question.
Thank you, Councilmember Page. Yes, it will involve commercial structures. It can involve any code section, be it, graphics code, which you're familiar with. By the way, Mr. Logan's a great help to us in the Northland area. He gives us a heads up on a lot of things and helps us with talking to some of the people. But to answer the question, yes, any code section involving commercial structures also.
So it is universal across the code.
Yes, yes.
Appreciate it.
Thank you, Mr. Logan. And I would like to welcome my colleague, Councilmember Shannon Hardin, to our hearing. And briefly, before we go to our next speaker, I will go over the code sections that this is going to amend. And the title, of course, of this legislation is to supplement the Columbus City Code by the amendment of Section 701.99, which I think is like health, 3305.10 and 3305.99, which is our graphics code, 4509.02, 4509.99, which is our housing code, and 4701.99, which is our nuisance abatement code, to clarify that no provisions of the Columbus City Code shall be construed to prohibit or limit existing remedies available by law. So all of those different sections will be amended to now allow code enforcement to more effectively, in some ways, address issues with repeat offenders. And our final speaker this evening is Ms. Lois Mayer. I'd like to ask you to come down. And again, you have 3 minutes. Councilmember Hardin, do you have any comments? Thank you. Ms. Mayer, if you could let us know any organizations that you are representing, and welcome to council.
As some of you already know, there would be more people here from the BECA and the MAC this evening, except there is a conflict, and that is the the presentation about James Road being discussed at Barnett Rec Center right now. So that's why it's just me representing all of them. My name is Lois Mayer, M-A-I-E-R. I am over the block watch for BECA, and I am representing MAC as well. I was a little concerned about some of the parts of this, and I have to say that some of your comments have clarified things that I would have more spoken to. I think with the answers that I've already gotten, that I'll be able to go back to those that were not able to come and assure them that this is probably a good way, at least to start, and then move on maybe from there. But I think I can tell them that we can go ahead and support this. We are anxious to see some teeth be into the rules and regulations where people are just blatantly just thumbing their nose at things that are happening. So we welcome that as we try to keep our communities from deteriorating in any way. We don't want that to happen. So thank you for letting us speak here.
Thank you so much for coming down, Ms. Mayor. And I would just like to acknowledge you and the work that you do with the MAC and Berwyn East Civic Association, because you all are really the impetus behind the administration, the city attorney's office, as well as council, really wanting to work together to get this moving. So thank you all so much. And again, I would like to thank all of the speakers who came down this afternoon and for your comments. You all are doing amazing work in our community, and we truly appreciate it. Before I give my final comments, do any of my colleagues have any additional comments? Well, seeing none, I'd like to thank Director Shoney, Administrator Dana Rose, and Assistant City Attorney Steve Dunbar for coming down and for your testimony this afternoon, as well as your work in putting this legislation together. I look forward to our code enforcement officers getting out there and really addressing the issues that we see with our repeat offenders. Additionally, I thank my colleagues for joining me this afternoon, my team, Rolanda Hampton and Sherry Martin and Andrew Dyer for helping put this hearing together, CTV, and all of those who have attended today. Thank you so much and have a good afternoon.